My name is Akube Ndoromo, the man that got robbed by Washington District of Columbia. Judge Emmet G. Sullivan of U.S. District Court and the Chief Judge Senttelle of U.S. Court of Appeals of District of Columbia proved out how corrupt the judicial misconduct going on in District of Columbia. See criminal number 6019 under Judge Emmet G. Sullivan and the appeal number 09511 D.C. Circuit. The due process clause requires the government to prove beyond reasonable doubt every element of the crime with which Akube Ndoromo is charged. If the government fails to sustain its burden of proof on any element, the defendant must be acquitted. Since the government fails to sustain its burden of proof on all elements in Akube Ndoromo's trial, he must be acquitted. You can see Lafave and Scott, Criminal Law, Section 1.8, Second Edition, 1986. McCormick Evidence Section 336 to 337. And also see 18 United States Code, Section 983, CFRA 2000. Also see United States versus Marillo. The Judge Emmet Sullivan, acting with an improper purpose personally by influencing the government, including making false statements and misleading statements to corrupt, violate Akube Ndoromo's proceedings during the criminal case by not acquitting him in reference to Title 18 United States Code, Section 1505, Section 1518, and 1001. See United States versus Kanchanalak, D.C. 1999. On September 5, 2007, the trial judge, Emmet G. Sullivan, told Akube Ndoromo that he knew the attorneys he was appointing to represent Akube Ndoromo have relationship with the government prosecutors. Akube Ndoromo went to trial represented by ineffective attorney in violation of Title 18 United States Code, Section 3006 AD6 and C. Holloway 435 U.S. at 484, and a violation of right to effective assistance of counsel because trial judge failed to investigate claim of possible conflict of interest on part of defendant's attorney. In addition, see United States versus Greg. Violation of right to effective assistance of counsel because trial court knew of conflict of interest but failed to conduct further inquiry. Also see U.S. versus Gelgos 108. Violation of right to effective assistance of counsel because trial judge knew of conflict of interest but failed to obtain either waiver or protect right to conflict-free representation. See Mana versus Tailaka. He was used to challenge constitutional right to be tried before impartial fact finder when judge failed to recuse himself. And see Johnson versus Jabez. Sixth Amendment right to counsel in criminal proceedings with the holds from federal courts the power and authority to deprive an accused of his life or liberty. The Civic Center in D.C., in Washington, D.C. generally, is filled with everything that made District of Columbia such an exhilarating and alarming city. Jostling, shouting, joking, cajoling, backslapping, backstabbing, bargaining, dealing favors granted, grievances paid with interest, intimidations, bribery, cancellations, grand gestures, absence remarks, and occasionally simultaneously act of generosity. The district court was given something. See trial transcript March 26, docket entry 67, entry day November 30, 2007, page 4 and 5, in reference to Title 18 United States Code 1505 and 1518. Based on district court's comment that the current LNC Epstein is a well-experienced attorney in pretrial structure, and pretrial structure permits artful attorneys like LNC Epstein and Jeffrey A. Taylor to hide the ball and keep alive hopelessness claims, as well as former defense attorney Rita Pendry, and for a much longer time than formerly. In many ways, contemporary federal litigation is analogous to the dance marathon contest of yesteryear. The object of the exercising is to hang on to one's client and then drift aimlessly and endlessly to the litigation music for as long as possible, hoping that everyone else will collapse from exhaustion, but it is obstruction of justice and a conspiracy to harm. At 622 ex-party Yangi 75 U.S. according in Re Bonney 151 U.S. 24 and more and etc. Also, when a prisoner is in jail, especially when Ndoromo was in jail, he may be released upon habeas corpus. That is when he was released when he filed to Second Court of Appeal in New York. Unconstitutional conviction and the punishment under a valid law will be as violated of a person's constitutional rights as conviction and the punishment under unconstitutional law. See Ex parte Prom 235 U.S. 694. All this evidence, it will be under the video, it will be posted in. If you see Act of December 23, 1914, and Chapter 238, Section 790, previously, the Supreme Court could not review such decisions at all. In addition, see Act September 6, 1916. All these details will be, of course, included in whatever posted. When error in relation to the federal question of constitution violation creeps into records, we have the responsibility to review the proceedings. That is what the Supreme Court say. I will end this one over here, and of course I will gonna include all these violations of Judge Emmet G. Sullivan and the violation of the Chief Judge of D.C. Court or D.C. Appeals Court, Senttelle, in it, and also you can see all these details in Ban Green Taban, or in Facebook, Justice for James and Stop Government Robberies. And also it is filed to United States Department of Justice Civil Rights Division. Thank you.